If we can have the next panel join us here, that would be very helpful. May I request Diana Citron. She's General Counsel, Proprium Capital Partners. Okay, why don't you all come here so I can introduce them quickly and then move on. Now sit back, relax, yeah? Yeah. Okay. Okay, thank you. So Dan, can you introduce yourself?
Sure, I'm Diane John. I'm the General Counsel and the Chief Compliance Officer at Proprium Capital Partners. We are a global real estate fund, and we are, as Tim said before, 30% invested in India.
Yes. We have met Nimitz,
Sure.
we are all informed, so please.
Matt Nimitz, I'm practiced law for many years and then was at General Atlantic as Chief Operating Officer for 12 years, recently retired. I also, we've invested a lot in India over the last 15 years.
Yeah. And Matt is also a mentor, by the way.
I'm a trusted advisor of Nishit Desai Associates. So I keep an eye on Nishit.
All right. Vaibhav?
Yeah, Vaibhav here. I am partner with Nishit Desai, based in Bangalore. I head private equity, M&A, and technology.
Yeah. And Nishal, again, you want to talk about yourself?
Yeah, no, nothing has changed in the last 1 hour. So
okay.
Same intro.
Few more kids in India, though. And Ruchir.
Yeah, hi. So I'm Ruchir Sinha. I lead the private equity M&A practice of the firm and also do a lot of structured finance and real estate as well.
All right. So I think I'd straight go into some questions, and I think let's work on that. That would be good. So then, as a general counsel, what are the risks that you generally encounter in India these days? Except the women's safety, that's taken care of.
Right. With the jewelry, right. It's not fair to make a lawyer go right after Jack. That just doesn't seem fair, but I won't be able to entertain you anywhere near as well. But there are a number of risks in doing deals in India. I'm sure everybody understands them. I would say, I would categorize them as both legal and operational. You know, when you're in the States and you're doing a deal in India, you really have to rely on your advisors. You have to rely on the lawyers because the laws are very different. Everything is different. The timing is different. Due diligence is different. And it takes patience, and it takes making sure that you have a really good team and boots on the ground because they're just things that move slowly and that are unusual, let's say. For instance, let's talk about a security interest, trying to get your security interest perfected. I remember in our first deal talking about the perfected security interest, and they said, yeah, well, you sign the documents, and then we'll go down next week. And I said, no, that's not really how we do it here. Here, if you want a security interest and you perfect it and I deliver the documents, you file the documents that day and I have a perfected security interest. Oh, no, we don't really do it that way. I said, yeah, well, I know you may not do it that way, but that's really how I want it done. And I lost. And the security interest did actually get perfected. It just did take another 10 days, and we got through it. Understanding how things work someplace different is also important. That's the other reason that you need your team. And you need the team to talk about cultural differences as well as legal differences. And you need to make sure that the team is trained and understands the Foreign Corrupt Practices Act and any other actions that they might take that would affect a U.S. company. And we happen to be a U.S. registered investment advisor. And as such, there are certain things that have to be done and can't be done under our laws, despite the fact that the deal is being transacted in India. India has been different for the past couple years, obviously, because they keep changing the laws, especially the tax laws and the corporate laws. It's not an easy thing to invest in equity if you're investing in real estate and you're foreign. It's much easier to do a debt deal and use the Netherlands or Mauritius or one of the other jurisdictions in order to keep your tax blight down as much as possible. So you have to keep an eye on the laws. And again, that's why it's important to make sure that you have really good and trusted advisors over there. And again, the timing issues are tough. I think from the documentation perspective, you just have to make sure that you have enforceability rights when anything could go wrong, because things could go wrong, and things do take a little bit longer time. And in order to keep people's feet to the fire, you really do need to make sure that your documents are tight. So again, it's reliance on your trusted advisors. From diligence perspective, operations perspective, enforcement perspective, you just need to make sure that those documents are really tight. And then finally, from an operational perspective, make sure that the documentation that governs the deal gives you sufficient oversight following the transaction in order to stay on top of it and make sure that people are doing what they said they were going to do and reporting as they were supposed to report. Again, because it is so far, timing is different, it's important to have that team in place and to be able to rely on them. So I think those are some of the bigger risks that we've come across, and hopefully there won't be too many more after that.
Thank you, Dan. Let me on that note turn to Ruchir. Can you tell something about evolving structures now that,
Sure. Yeah, I think in the Indian context, I think we always have evolving regulations, evolving laws, and therefore evolving structures. Some of the structures, I'll be talking about 3 or 4 structures. Some of them have kind of already evolved, but their usage in that sense hasn't been, that appreciated. So I think the first structure is really the listed debt or the structured bond product, which is increasingly being used in India. And, we pioneered this in 2008 for the first time for what we call as promoter funding then. So what happens in this structure is that, an Indian company would issue bonds to a non-resident. These bonds are listed, but the listing is really, way too simpler than equity listing. It's just a process of a couple of days, disclosures of a couple of pages, and fairly simple. Once the non-resident is able to subscribe to these bonds, these bonds would have kind of 2 elements. One would be a coupon, and the other is redemption premium. And the bond helps you, so the bond functions really like an equity instrument in that sense if you wanted to. So the redemption premium of the bond can be a function of cash flows in the company. So if the company is making less, the returns on the bond are less. If the company is making more, the returns on the bonds are more. So it really is able to kind of give you the downside protections of being a bond, yet giving you equity-like features in terms of its ability to kind of capture the equity upside. The other, in India, there's a huge challenge in terms of how do you distribute, because any amount of distribution by way of dividends or buyback entails about a 20% additional tax on the company, which is not even creditable. And capital distribution is even more challenging because that can happen only in a staggered manner, unless done by way of court approval, which again is pretty, cumbersome and takes about 4 to 6 months. But if the returns are disputed by way of a bond, then one is that there is no distribution tax of buybacks or dividends as you would have in case of equity, because whatever you pay on the bond, whether you call it coupon, redemption premium, is a deductible for the Indian company. Therefore, not only are you saving first on your corporate taxes in India of 30% being a deductible, whatever you are paying out is actually an expense. So there's a massive tax saving over there. And there's a nominal withholding tax on whatever upside you pay on these bonds. In case of Netherlands, it's about 10%, Singapore about 15%. So, and mostly these kind of withholding taxes paid on these interest or coupon or redemption premium is creditable in the recipient jurisdiction, therefore neutralizing the Indian tax effect to a substantial extent. Now, where are these used? Of course, it's being used increasingly in real estate because real estate, as you see, is a self-liquidating market, or there's constant cash streaming which is required. So because of the structure of these bonds by way of interest coupon redemption premium, it makes the tax, it makes the upstreaming of cash from the company very, very tax efficient. The other benefit which this kind of an instrument gives you is also in terms of security creation. Diane just talked about security enforcement in real estate, and she's increasingly, I think your all India investments are through the listed bond structure. And because in real estate, the challenge was that many times Indian promoters said that, ROI does not mean return on investment, but return of investment, which sometimes made, foreign players pretty apprehensive. And what this instrument lets you do is lets you create a security interest through an onshore security trustee. So you can have pledge of shares, mortgage, guarantees, whatever. It gives you complete security. One of the, because this bond is really subscribed to under what we call as the foreign portfolio investment route, because these bonds are listed, it is not subjected to the sectoral conditions and restrictions as foreign direct investment. So we have limits in insurance, we have limits in single brand retail, we've got brownfield investment challenges in context of pharmaceuticals and healthcare. All those restrictions do not apply when you invest through these bonds. So these bonds have been structured in the past and continue to be structured in a manner that while, so you would ideally take a small portion of equity to the extent that it's allowed, and you can still kind of capture substantial amount of economics through these structured bonds by way of structuring through redemption premium and all of, and coupons. And as lending kind of grows, and I think for those people into special situations and other stuff, substantially, these are also used in lending structures, and there's a massive combination of non-banking financial companies and NCDs which are kind of increasingly becoming common, because this really works well with financial services industry, because there's interest income coming in and interest income which is being expensed out by way of these bonds. The the other structure which I think especially makes more sense for those in the technology sphere, healthcare, et cetera, is using the foreign venture capital investment route. So foreign venture capital investment regime is a regime that was initiated for venture capital investments. It's a registration that you get from the SEBI, which allows you to invest without any pricing restrictions. There is a massive debate today in India on valuation mismatch and all, and which is being, which is typically addressed through convertibles. But in India, entry and exit is governed by pricing norms. And if you come through FVCI or the foreign venture capital investment regime, there is no pricing regulation applicable. So it's a lot more, it's a lot more aligned in that sense. Another benefit is, sorry, let me know if I'm exceeding the time. And another benefit is in terms of public offerings. Many times there might be private equity players who may not want to offload their entire stake in a public offering. If you were coming under the FDI route, there's a lock-in of 1 year. That means if you do not sell your shares in the OFS, you will need to hold them on for a period of 1 year. But under foreign venture capital investment route, there's no lock-in, so you can really see when do you want to exit from the company. And again, redeemable structures like optionally convertible debentures, optionally convertible preference shares, assured return structures are all permitted under the foreign venture capital investment route. So those are really two investment routes. Another trend that we've been seeing is externalization. I think Weber will talk about the challenges that the new Companies Act in India brings about, but many standard private equity terminologies like liquidation preference, conversion, into any pricing that you want, all those things kind of become a little challenging in the Indian context. But if you externalize your company, that means you set up a holding structure in Mauritius, Netherlands, or Singapore, with Indian company doing the real operations, all these challenges can be sorted because then foreign investment can really come into the holding company, like the way it's very common in China. Most of the Chinese company have operations probably in China, but are structured out of Cayman or Hong Kong. So that externalization is, I think, becoming increasingly common. We've done that for quite a few tech companies. It's usually better at an early stage, but with the right structures, we've kind of managed to externalize matured company as well with minimal tax leakage. Also, I think it helps from a exit perspective, because in India, if you keep building value in the Indian company and keep expanding it, when you sell, there's a massive tax leakage, in India. And the last structure is using the depository receipts, or ADRs or GDRs, which were earlier pretty much restricted because we only allowed those companies to list abroad which were already listed in India or promised to list simultaneously. But in the past year, those regime, the ADR, GDR regime has been liberalized, and now Indian companies, whether listed or unlisted, can do a DR program, whether sponsored or unsponsored. And the interesting part is that we have all these general anti-avoidance rules, etc., which Nishit and others spoke about. But if you're selling depository receipts on the floor of the stock exchange, then there is no question whether you're coming from Mauritius, there's substance in Mauritius or not, because sale of depository receipts on the floor of the stock exchange will not be taxable in India under Indian domestic tax law itself. So it's pretty tax optimized in that sense. So those are really the the four structures which we see evolving and coming up. Happy to answer any questions.
No, thank you, Ruchir. I think in the shortest possible time you compressed so much. And
sorry, I just want to add one thing to what Ruchir said on externalization. I think what Ruchir mentioned is something we are seeing it. It was discussed earlier also that Indian companies, instead of being incorporated in India, they incorporate outside India as a holding company, and then you have the operating company actually sitting in India. There are advantages of doing it. A lot of people are thinking of doing it, but there are always challenges of doing it. And the key challenges are under exchange control regime, under tax regime primarily. And we find that it is not always possible to flip the company outside India. It can be done in certain situations, but it cannot be done in all situations. And wherever it can be done, there are always challenges. So this is something you tread with care. You don't simply do it as a work.
So today we see a lot of companies that to start with get incorporated outside India, in Singapore or other jurisdiction, mainly because once you set up a company in India, it's like inversion. We are also seeing that situation, and the difficulty is that once you put your neck in, then all structuring becomes and restructuring becomes very difficult. But without going into many details at this point in time, I think Matt, maybe you can talk a little bit about exits issues in India, and you have a lot of experience, so sorry for that.
Yeah, so I'll try to be brief. We've always done minority investments for over 35 years in the U.S., all around the world. So exits are very important for us. And our investment committee, when we make an investment, one of the questions at the investment committee is always, what strategies are there for an exit? And we don't make the initial investment unless the team can make a case that there are alternative possibilities for exit, because the last thing we like is to be stuck in an investment, which has happened from time to time over our 35-year history. But we try very hard. And India poses some special issues for us. But just historically, I could say that in our firm as a whole, probably 50% of our exits have been through public offerings, and the other 50% have been through some sort of sale. So that's sort of historical. When we come to India, though, and we've been in India, our first investment was 2000, I think, Daksh, and Putney Investments in 2001 or 2002. So we've done lots of exits in India, and they've they've all worked, they've all been successful, and we've had good counsel, Nishant Desai Associates. So we feel very good. We've invested over $1 billion in equity in private equity in India. So we feel that it does work, but it does pose special problems. One thing is the public market route that we use in the United States a lot, and we've used in Europe, is very problematic in India. First, the cycles are really pretty dramatic. So there are periods when the public markets in India are just not susceptible to taking in taking sales of company. The values are too low. And then when the values go up, that's the time to sell. But very often there are reasons why you can't sell then. So we have to worry about the cycles. Second issue is the promoter or the entrepreneur. And in the U.S., we find that most entrepreneurs have a view of the company, of holding it for a number of years, and then at the right moment finding some liquidity event for themselves and their families or whatever. But in India, you really need to spend a lot of time with the promoter, entrepreneur family at the beginning before you make the investment to understand whether you're aligned on your liquidity options. Because a lot of Indian family entrepreneurs think of the company as something they want to hold for themselves and their children and their grandchildren, and really don't necessarily have a view of going public. And sometimes we feel that to induce us to invest, they say they will go public or sell the company, but they really don't have that intention. So it leads to a certain tense, stressful relationship between the investor, who has maybe a 5-7 year time horizon, which is our time horizon, compared to the entrepreneur who might have a much, much longer time horizon and doesn't really want to have a public company. And if the entrepreneur doesn't want to have a public company, even if you have provisions in your agreement that says you should, it doesn't work if he or she doesn't want to move that direction. The other role is a strategic sale, which we thought would be possible in India. We thought foreign companies would come in, buy up companies more. There'd be a consolidation process. And that didn't really work out quite the way we thought. There were some strategics. We have sold to some strategics, but much, much tougher to go down that route in India. So the liquidity part is much tougher. Now, what we found is more sponsor-to-sponsor sales. So we've been on both the buying side and the selling side, and we've exited a number of times, especially recently, to other sponsors. And when you see the list that was up there earlier of all the private equity firms coming into India, well, they're going to have to put their money somewhere. Where are they going to find good companies? Where are they going to find good minority stakes? Well, they'll find them from other private equity firms that have held a company for 5, 6, 7 years, 8 years, and they're ready to sell out. And those companies have some advantages. One is the advantage is they're usually good companies. Second, they have entrepreneurs and management that are used to working with Western investors. So General Atlantic selling out and another private equity firm coming in is something that they feel comfortable with, and the private equity firm feels comfortable buying into that type of company because the management knows how to deal with minority foreign investors. So we found these sponsor sales are a logical place, and when I see more and more dry powder coming in, I'm thinking more and more about companies that we ought to try to sell to them while the values are high, and they're telling their investors they're going to enter the Indian market. I should say there's some special problems. So that's sort of the psychology of the sale and the timing of the sale. I do want to emphasize the cycles that you have to assume that there are going to be periods when you're not going to be able to sell anything because the values are too low and the atmosphere is negative. And then you get these highs with the Modi. Maybe it'll last for a long, long time, or maybe it won't. I mean, we've been in Brazil, and we know what it's like when you have a high-flying economy, and you also know what it's like now. The types of reps and warranties on sales, I want to make a point about that. When you sell to your piece to another sponsor group, you don't want to give many reps and warranties on the company. You're a minority investor. You're selling a block. But of course, the entrepreneur, the company, is not going to give reps and warranties either. So you have a real tug of war between a sale of a block, and then you have this issue in India, of the withholding tax risk on a sale, whether that's a real issue, and the council can talk more about that. But there are indemnities that go, and there's reference in one of the prior panels to this, that the buyer says, well, there might be and India is one of the few places where if this seller doesn't pay the tax, and there is a tax, the buyer can be liable for the tax. Well, the last thing a buyer wants is to pay the tax for the seller. So the buyer says it needs to be some type of indemnity or escrow, and you get into that type of negotiation, which usually results in a rather long liability risk for indemnities. Which for a private equity firm is always a question of who's going to be around on the LP side to help pay those indemnities, tax indemnities, if they ever actually come to fruition. So there are a number of issues. And you talk about externalization. That is, you do what we do in China, and that is you have an outside company, and you flip the outside company. And there are some issues there too. It does, as Vaibhav says, it doesn't always work, or there's risks of having that type of structure in any event for companies. So bottom line, exit is a riskier thing. Exits are always risky in private equity. They're riskier in India for structural reasons and for cyclical reasons. The last thing I would just want to mention, because not too many, someone mentioned it earlier in a question on the currency and whether the conversion of rupees to dollars makes a big difference. We've gone through that, and in exits, we're obviously very sensitive to timing, and there's no way to hedge private equity that I've ever figured out, long-term private equity. So we have to be very courageous in these investments in emerging economies, and we understand that, and we take that into account in our assessment and our models when we go into the investment. And we go into an investment with our eyes wide open that the currencies will gyrate, and we may get some benefits out of it when the dollar is weak, as we have over the period of the last 20 years and during certain periods, but we also can be hit rather hard by wonderful companies that when you look at it at the end, you haven't made any money because of the currency factor. So that's a big risk, which I think we have to, all of us who make long-term investments, have to really factor in. I'm not sure we all factor it in well enough. Thanks.
Thank you, Matt. This is a very good summary of But all this also has something to do with regulatory issues. And Weber, could you just tell some other issues relating to regulatory regime that we have governing the PE?
Sure.
But before you get into answer, what we'll be doing, just to get back on time, we'll break the break. So, we'll not have a break. We already had one in between. So without too much of delay, we'll be able to continue. So
Sure.
if you could be a little quick, but that would be helpful.
Okay. Yeah, I will try to be quick. Unfortunately, regulatory regime, you can never be quick. There are a lot of changes, and what I will do is I'll just restrict to some of the changes which has happened in last few months. I was here last year, 10 months ago. I don't know, some of you may have attended. I talked about New Companies Act, which was brought in, and there were 3 or 4 key issues which private equity was facing because of the New Companies Act. I will just talk through them, the issues which we're facing and what has happened in last 10 months and how are we navigating through it. One of the first issue which you were facing in the New Companies Act was, New Companies Act said that, look, if you want to give an ESOP, you cannot give ESOP to founders. You cannot give ESOP to director who has 10% shares in the company. You cannot give ESOP to consultants and non-employees. The issue still remains as it is. Law has not changed. We're working hard with government, with NASSCOM, and with other bodies like CII to try to kind of liberalize this particular regime, because ESOP is heart of investment, especially in tech companies. But there are, in certain cases, there are structures which can be used, like, for example, employee trust or some other kind of a trust, or issuance at a partially issued shares, which can be used to meet the requirement or meet the objective of what ESOP was conveyed with for some of the founders and some of the other issues. So there are structures which are there, and they are accumulated. They are not very what do I call, simple to implement, but we can achieve that objective, but still the best option is to go and change the law. The second issue which we faced when the New Companies Act came in was when we were looking at preferential allotment to private equity. 2 things came up. First, under New Companies Act, they said you can only issue at a fair market value. Now, often that became questioned because your company issues shares to someone else at a particular price, and now how do you justify the change in price so fast, so early? Good part is that that kind of got clarified and got changed, where it says that it's not at just fair market value, but it has to be either at fair market value or above fair market value. So it is no different than what foreign investors were used to under exchange control regulation, where you need to put at minimum of fair market value. So that was something which was a good clarification which came up later in the year. The second issue which they were facing was with respect to, when it comes to preferential issue, was with respect to filings and basically disclosure of information which they need to give to the Ministry of Company Affairs. And what they used to do is that instead of going through that particular route, they said, why don't we do rights issue? Rights issue typically has a lot more flexibility, and what the law allows companies to do on rights issue is once you go for rights issue and there are subscribers or shareholders who don't subscribe to the shares, then you can actually issue it. The directors have a power to issue it to anyone else as long as it's in the best interest of the stakeholder. Now, that particular route became quite popular, or companies wanted to go and do it. However, question always came up for private equity who was coming in for the first time, that is it okay for me to get shares under the rights issue? And what we have seen is that in some question, Reserve Bank of India has actually questioned the rights issue under FEMA Exchange Control, not under Companies Act, but under Exchange Control. And we see that it is not always a good idea to go under rights issue. So there are situations where, for example, your company is doing a rights issue and there are more than 2 or 3 current shareholders are actually subscribing, and then one more shareholder is just coming in. Maybe that may work, but in many of the cases, it's better to go under preferential issue route, even though there is an onerous or more obligatory information disclosure requirement. Third point which we had seen is there was a restriction on issuance of securities with differential class or differential voting rights, you wanted to do a Class A share, Class B shares, those kind of instruments. There were restrictions under New Companies Act because the New Companies Act said that, look, you can only issue equity and you can only issue preference shares, that's it. And preference share will be non-voting in nature. So really kind of reduce flexibility for investors to get different classes of shares. That particular thing has been relaxed now. In fact, none of the restrictions on issuance of shares apply under the Companies Act, which means that now you can issue, Indian private companies can issue any kind of instrument they want without any restriction. Though under exchange control regulations, it is still mandatory for foreign investors to have equity shares or compulsorily convertible instruments. So that's something which we need to keep in mind. But at least it gives you a lot more flexibility to have a Class A share, Class B shares with different rights, different voting right, different dividend right, etc. Fourth, on directors' liability. A lot of things have been discussed. There has been lot more what do we call cognizance of liability. The New Companies actually codified what are the rights of the directors, but they also codified what are the duties of the director. And now liability is in much more stronger foothold in terms of what kind of liability would apply to a particular director. The good part is that for the nominee director and for the independent director, as long as they are able to prove that there is, they either did not know about it or they did their due diligence, to that extent the liability can be minimized. So there are ways to minimize the liability, but that's something which also needs to be kept in mind. Another new development has happened and is under insider trading regulations. Under insider trading regulations, I think for the first time we are seeing that not only listed company is covered under insider trading regulation, but also company which is to be listed, so pre-IPO companies is now covered under insider trading regulation. Now, first question is, what is pre-IPO company? And again, we don't have a very strong clarity under law on what is pre-IPO company. But what we believe is the moment company passes, or the board of the company passes a resolution to go public, that would be considered to be a pre-IPO company. So what is important to keep in mind is that it's just not the listed company, but companies which have announced or which have intended to go public is also covered. The other change in the insider trading is that the definition of insider has been widened. Obviously, the company officers, the directors, and some of those employees will be covered under insider as it was earlier. But now people who regularly correspond with the officers will also be covered under definition of insider, which means that if you're an analyst and you are regularly talking with the company on a regular basis and getting information, then you may be insider. Again, what is regular communication is not defined. There's no bright line test, but you will need to see facts and circumstances to determine whether it's a regular communication or just one-off communication. What is the impact if you're an insider? If you are an insider, then when there is a dealing of shares, it is presumed that you had an UPSI unless you are able to prove that you did not have a UPSI. UPSI is unpublished price sensitive information. So as an insider, the onus of proof or burden of proof is on you to say that you did not violate any insider trading regulation, you did not have any UPSI, and that's something which is very critical to keep in mind. What it means for private equity and funds, it means that if you are in a regular touch with the companies, you're analyst in regular touch with the companies, it's very critical to make sure you keep a proper evidence to say that, look, you did not get a UPSI from the company. Third change or fourth change which has come in is earlier the violation of insider trading regulations was only if it resulted in dealing with shares, which means either you bought the shares or you sold the shares. If you got a UPSI but you did not act on it, there was no violation. Now the very act of either obtaining a UPSI or giving a UPSI in an inappropriate way or something which is not official way is something which can be considered to be violation of insider trading and can lead to penalty, which means that the tipper and the TP concept which exists in the US is also now applicable in India. And again, this has gone beyond just someone tipping it, but it also means that if you are getting an information, even accidentally, you may be covered as an insider, and you may have been you may have to follow the insider trading regulations. So those are the changes which have come in. Last point I would want to do would be with respect to Competition Commission. What has happened is, first of all, under Competition Commission, a fund which is investing in India do not get covered if you are investing below 25%. So this only applies if you are investing about 25%. But if you are investing about 25%, then you need to look into what is the, whether you met the threshold or no. Now, one threshold is with respect to what is the size of the target company. That particular threshold, if you meet, then only you go and look at the other thresholds. This particular exemption of target company, which is currently one of the most utilized exemption which people go under, which is if the target company is lesser than 2.5 billion rupees in terms of assets and 7.5 billion rupees in terms of turnover, then you don't need to go and seek competition approval, Competition Commission approval. So, in case you have the target is below this particular amount, you are fine, but this particular exemption is expiring next year. And if it is not renewed, that even smaller transactions can get hooked into the Competition Commission. So that's something we need to keep in mind. This will be true especially for the exits when you do. The other issue with respect to competition law is there is currently a question mark when you go and acquire more than 25%. Often question comes that do you meet the global threshold of what the law puts it in, and you may say, well, I don't meet the threshold because my fund size is only so much, but there is a question mark today, and there's a lack of clarity today where whether the fund which you're investing is the only assets which you count when you calculate the threshold, or all the funds which are controlled by the same manager or manager's parent also gets counted for purpose of calculating the threshold. And a lot of time those kind of issues become very critical when you are deciding whether Competition Commission approval will be required or not. So that's something you need to keep in mind. Lastly, just a statement here, new laws, new alternate exchange guidelines have been announced, I think 15 days ago, if I'm not mistaken, which basically allows institutional trading for technology companies. They are interesting, not applicable to many of the companies which you have invested in. But if it is applicable, then that becomes a very interesting way from exit perspective. So I just thought I will mention it. If anyone wants to know more, I can talk in Q&A.
Excellent, I think that was very useful in spite of the fact that we are running a little late. But this input has been very helpful in light of exits and other situations. So I won't ask too many questions now, but at least initial. Just one or 2 points on structuring exit in context of tax.
Sure. So, as Matt mentioned that there have been very few exits for private equity funds in India, and out of those fewer exits, very few exits have happened through public market sale. So most of the exits have happened through sponsor to sponsor sale. Now, the problem arises because of the weird system in India that the seller earns capital gains, but the buyer has to pay tax for the gains earned by the seller, which means that ultimately the buyer is held responsible for the taxes which the seller needs to pay. The issue which arises is that because we have a tax treaty with Mauritius and Singapore, and most of the investments in India are structured through Mauritius, Singapore, or Netherlands. Earlier it was Cyprus also, but because of certain issues, Cyprus has been blacklisted by India. The challenge arises because from a seller's perspective, the view that the seller takes is that the transaction is not taxable at all. From a buyer's perspective, he feels that this is at the end of the day seller's tax. So even if there is a slight uncertainty on the taxability of the transaction, he would not want to take the risk and he would want the seller to take the risk. Now the statutory period of limitation for tax liability in India is 7 years. In a sponsor to sponsor sale, the biggest issue which arises is most of the private equity funds are set up as limited life funds of between 7 to 10 years, and most of the exits happen at the fag end of the fund life, which means you are exiting either after 6 years or 7 years, which means your remaining fund life is only 3 to 4 years when you are exiting, or even less than that. Now if your fund life itself is less than 3 to 4 years, how can you give a tax indemnity for 7 years to the buyer? And this becomes a big issue when you are negotiating the exit, because the buyer would want complete protection on the tax liability for the seller. Some of the typical discussions which happen while negotiating tax indemnity is, one is, let's take a tax insurance, and there are insurance companies which insure the tax risk for the buyer and the seller, which is the best solution. You just pay a premium, and both the buyer and the seller can insure the risk and not worry about the tax liability even if it arises after the end of the fund life. But the challenge is currently there are no insurance limits available for insuring tax liability risk for India. These limits open up sometimes there are no limits, so it's very situation specific. Second is escrow of the tax amount, which typically no seller agrees, because that means he doesn't have money to that much amount to access, and it's as good as a withholding of tax and paying to the government as far as the cash flow is concerned. Then there is a concept of private letter ruling which can be obtained from the tax authority, but that itself again takes about 2.5 to 3 years, which again defeats the entire purpose of getting certainty on the transaction. So the maximum negotiated clause in any exit transaction is the tax indemnity. And we have seen various types of requests coming from the buyer side on that, okay, fair enough, your fund life is getting over in the next 3 to 4 years, but we want tax indemnity for 7 years. So why don't we get the proceeds from the LPs in case the fund life gets over? And can you give us some undertaking that either it's part of your fund documents that after your fund life gets over, you still have the flexibility to claw back the tax indemnity portion from your LPs? Or if that is not possible, then let the GP give the tax indemnity post the end of the fund life, which means, and the GP would say, hey, I'm only entitled to 20% carry, and why should I take the risk of 100% of tax indemnity? So lot of challenges in negotiation of tax indemnity. Each exit has to be negotiated in a different way depending on the facts and circumstances of the situation. But yeah, currently tax is one of the biggest challenges in negotiating the exits.
Yeah, thank you, Nishchal. Wonderful, and we have exceeded time quite a bit. Really, it's an interesting discussion, but if we can close the panel at this point in time, I would really love to have some questions. Anybody has any questions by any chance? No, I think not. Okay. So let us thank each one of you here, and we appreciate your time, but unfortunately we ran out a little bit. It was very useful insight that you all provided. So let me thank you all, and maybe have a little memento for them.